we heard from President Peterson there's 23 or so suspension and abeyance cases. I had the attorney from a different firm, Chortelig by Ear, who has another of these cases. They're going to be trolling for these suspension and abeyance cases. They're looking, they see a payday from the people of the state that's in the multi-millions. And they're going to find them. And quite frankly, with Judge Peterson's report, and to the Regent's credits, they let that come out knowing that, because the facts are what they are. And that's the way the people of this Board of Regents act. But that's a gift, and that's going to cost the state millions. I'll take questions. Chairman Rice?
No questions.
Any other questions? Members of the committee? Paul?
I think you may have mentioned it, but when did you get into this process? How?
Regarding the Phi Delta Theta issue?
Yes.
Virtually the day of the alleged incident, I
Okay.
learned about it, and I've been there ever since.
And you know, a second question is how much were you able to lend information and legal expertise to your client in this matter, and it was accepted by the institution?
We were there at every meeting, or I was there at every meeting. We advised them at the student hearing itself. I was present, but I was not allowed to speak. I could whisper in the ear real time and try to get things to happen, but as you can imagine, that was a challenge.
Okay, thank you.
Yeah, thank you. Have you, in your representation, will you file a civil case, or you still go through an appeal type of a process now?
In the Phi Delta Theta case, we have not filed a civil case. We're still running the appeals process. As I mentioned, I am involved in another case that's actually been filed, and it's pending in the Northern District of Georgia.
Same type of
That is a sex assault type case. And I will say in that case, on the eve of having the preliminary injunction hearing, the Board of Regents came and reversed for the second time the finding of the school to expel the student. Or to
Have you asked
suspend the
for
student.
any material damage in that situation?
Yes, client is asking for damages.
Not
How
Phi
much
Delta.
damage?
I don't know at this point, but I would expect it to be more than $1.
Take a look in some of that material. There's 200-something cases. Those damage rewards are massive. I don't know on this case. Yes, sir. Chairman Rogers.
Mr. Hawkins, just for the record, you keep talking about the administrator. Who are you preferring? Who are you talking about? Are you talking about the dean? When you're talking about, you didn't have recourse or due process.
I dealt primarily with Mr. Packett.
Okay. Primarily 90% of the time, 95% of the time?
I would say most of the time, as I said, at some point it was clear he was biased. We asked that he recuse himself. He refused. At the student hearing, he did not sit in, but someone else in his office actually sat in on that meeting. We appealed to the dean, Stein. So, the entire office was involved. We've filed open records requests, and it's clear that through email traffic that multiple people were aware of what was going on real time.
Okay, thank you.
I see no further questions. Mr. Hawkins, thank you for your time.
Thank you, Mr. Chairman.
Members of the committee, we have one more individual to testify. This is Mr. Robert Shibley. He's the executive director for the Foundation for Individual Rights and Education. They deal with this on a national basis. Mr. Shibley, welcome. I'm glad you got out of the snowstorm in the Northeast to make it here. Yeah, it's a little bit warmer here than it is D.C.
I actually have the blessing of living in North Carolina and working from there. So
yeah, well, Charlotte's no better. That airport's close to.
Well, having heard all the testimony today, and I know we're going long, so I'm going to hit.
Take your time.
I'm going to hit some of the. I'll try to hit more of the high points and not repeat stuff that you folks have already heard. as we've heard a little bit about, over the past 5 years, thanks in large part to unprecedented intervention by the federal government in the form of that Dear Colleague letter, the situation for due process particularly has gotten markedly worse. I am the executive director of FIRE, the Foundation for Individual Rights in Education. We defend individual rights, including, we're mostly known for First Amendment work and freedom of speech work, but since 2011, an increasing amount of our work has had to do with due process. And frankly, students are routinely deemed harassers, abusers, and rapists, and suspended or expelled from school without so much as a hearing. I want to assure you that nothing I have heard here today has been unusual to me. I have taken, like Representative was saying, I've taken myself personally dozens of calls, spent hundreds of hours on the phone with mothers, with students who are struggling through these very things, not just in Georgia, but across the country. This is a serious problem. And we know that there are dozens or maybe hundreds of lawsuits currently outstanding. I know this has been a big concern here today. The number one most common question I get from everyone, to legislators, to parents, to members of the public when they hear about what's going on campuses is, why in the world are campuses holding sexual assault trials? Shouldn't that be a matter for the police? Yes, that should be a matter for the police. Most forms of sexual assault are felony crimes, and campuses are not supposed to be enclaves free of the law. For the protection of everyone, sexual predators need to be removed not just from campus, but from the streets. And colleges, as we've seen today, don't even come close to having the ability to competently decide whether someone has committed a grave felony. Now, right now, colleges, and President Peterson talked about this, they feel they have no choice because of the federal government's current interpretation of Title IX coming through that Dear Colleague letter from April 2011. That was the letter where they required the use of this preponderance of the evidence standard, which is a 50.01% certainty standard, as opposed to what we're all familiar with from the criminal system, beyond a reasonable doubt, which is usually considered to be 98 to 99% certain that something happened. OCR also strongly discouraged parties from being allowed to cross-examine each other, despite the fact that, according to the U.S. Supreme Court, cross-examination is the greatest legal engine ever invented for the discovery of truth, and that's the quote. FIRE believes this mandate is unlawful, so do other people. Senator Langford from Oklahoma just sent a letter about it. And in fact, there is an op-ed from a Harvard professor in the Wall Street Journal today talking on this exact issue, so I urge you to look that up if you want to know more about the details of the OCR letter. But it gets down to the fact that this mandate has made, is a reality on the ground, whether or not it's legal. It's a reality that's made the shameful lack of due process protections even more acute. And at process, we've seen due process is the collection of mechanisms that make sure that when we are accused of a crime or other wrongdoing, we get a fair hearing. Most people would recognize a lot of them. Americans expect trials to be presided over by experienced, impartial judges. At either party's request, the truth of the allegations is determined by a jury of one's peers. The parties have the right to representation by counsel. A mandatory process of discovery ensures that all relevant evidence will be made available if the opposing party asks for it. Rules exclude hearsay, rumors, and other irrelevant or unreliable information. Testimony is given under oath, with liars subject to perjury prosecution. And of course, you have the Fifth Amendment protection against self-incrimination. So I think at this point, after what we've heard, you can guess how many of those you have in a campus court, or you can count on having. The answer is 0. You can count on none of them. Some campuses offer some of them. Virtually no campus in Georgia or anywhere else guarantees all of them. And yet, in defense of we lawyers who often get a bad rap, it's taken us 1,000 years since the Magna Carta to come up with these due process protections. They're not there just as window dressing on the justice system. Georgia is not an exception. What you're hearing today, like I said, is not an exception, and I'm sure, although we talked to the Georgia Tech leadership today. It's happening all across Georgia. I'm confident of that. Many colleges in Georgia have dispensed with a hearing in sexual misconduct cases in favor of that investigative model, where one person or a very small number of people investigate and decide the outcome of the case without holding a hearing or even giving the parties an opportunity to confront one another. And as I just learned today from testimony, apparently in this system they're also willing to punish a group of people when they can't locate the actual perpetrators of a crime. They're just going to punish everybody in the immediate proximity. Now, to see how these are increasingly being treated, East Georgia State College policies are instructive. At East Georgia State, here's a quote. The complainant and the respondents will be interviewed separately by the Title IX coordinator or her designee, during which time they should present any information in support of their respective positions. Interviews with the Title IX coordinator constitute the hearing. Did you manage to get an attorney? He can't say anything. If you want to accuse if you want to directly question your accuser's story, not only can you not do that, you aren't even entitled to see what he or she said. Do you have questions for witnesses? You don't get to ask them. Would you like to see all of the evidence against you? You're not entitled to it. Is the case against you based on hearsay and rumors? That doesn't matter if the investigator believes them. Is your accuser under oath? No, he or she is not. Would you like to be judged by your peers? Too bad, you're going to be judged by the prosecutor. Did new information come to light after your questioning? That won't help. At an appeal, quote, no new information may be presented. And of course, there's no mention of the right to remain silent.
Where was this?
That's East Georgia State. East Georgia State
East Georgia
University.
College.
But other schools in Georgia that use a single investigator model, and again, the details can vary from state to state, include Clayton State, campus to campus, Clayton State, Kennesaw State, the University of West Georgia, the University of Georgia, whose policies are actually, from what I can tell, very similar to East Georgia State's, and perhaps most notably Georgia Tech. I was going to tell you a little bit about the Georgia Tech accusations, what's going on here, but here's some of the details, and it's important to know what's being charged so we can know just how important the lack of these due process protections has been. So in these lawsuits, combining some of the allegations from them, they say that Peter Paquette withheld crucial evidence, failed to interview critical witnesses, refused to let the accused see the testimony against them, drafted investigative reports that included rumor and innuendo, such as an unidentified witness's statement that the plaintiff was, quote, unpleasant and creepy, unquote, refused to recuse himself despite the fact that he worked very closely with one accuser in her role as a peer sexual violence educator, and generally acted in a biased fashion, even laughing, allegedly, at one plaintiff's attorney as he pleaded for Paquette to interview some key witnesses. Now, this is only the student's side of the story, and a court hasn't ruled on the veracity of the complaints. And a court, and not the legislature, is the right place to do so. But what makes these important, and I hope you'll notice this, is all of the alleged abuses I mentioned here are all problems of the due process protections I mentioned before. The very protections that East Georgia State, Georgia Tech, and other Georgia schools have abandoned were designed precisely to avoid. Nobody should be surprised by such complaints against any single investigator. If we could always rely on a lone authority figure to be competent and totally unbiased in dealing with crimes, we wouldn't have come up with police, courts, prosecutors, defense attorneys, and so forth. Yet in the current campus climate, the public can only hope that colleges will somehow produce a class of Title IX coordinators and single investigators with the wisdom of King Solomon, all the while knowing that any such system, no matter where it is established, is far more likely to produce Inspector Javert. History is replete with situations where mere innocence is treated as no defense to an accusation. Due process is a free society's answer to this problem, and when it's weakened, miscarriages of justice can happen to anyone. And if history is any guide, that anyone will disproportionately be composed of members of political, religious, racial, or ethnic minorities, or of other unpopular groups. Last February in the Harvard Law Review, Harvard Law professor Janet Halley wrote this, quote, "Case after Harvard case that has come to my attention, including several in which I have played some advocacy or adjudication role, has involved black male respondents," unquote. A lawsuit filed last month against the University of Findlay in Ohio alleges that since 2013, 100% of the students expelled for sexual assault have been African American males, despite the fact that they make up 1.7% of the student population. That this could happen when due process is neglected should not be a surprise at all. Just as the First Amendment is at its most important when dealing with unpopular speech, due process is most important to accused parties who otherwise might not receive a fair trial. Properly implemented, it includes safeguards against both conscious and unconscious bias, racial and otherwise. But campuses have dispensed with most of these protections. What did they think would happen? At this point, solving the due process crisis on campus requires a legislative solution. Most importantly, state legislatures can provide students specific protections to counteract the damage that OCR has done in this area. North Carolina, North Dakota, and Arkansas have all passed right to counsel legislation, guaranteeing public university students the right to hire a lawyer who can participate, not as a potted plant, but fully participate in campus disciplinary proceedings. 2 bills recently introduced in Congress would also shore up students' due process rights by securing the right to counsel, eliminating the single investigator model, and requiring universities to disclose exculpatory evidence to accused students. I had written here something they shockingly don't always do, but we just heard that that happened. But the Georgia legislature need not and should not wait for Congress to act. It has the power to require that Georgia public institutions guarantee a decent baseline of due process rights to students and faculty accused of disciplinary offenses. The sooner action is taken to shore up fairness and justice for Georgia college students, the better. Not just for students, but for Georgia taxpayers. Indeed, the most recent landmark federal case about due process comes straight of Valdosta, Georgia, and Valdosta State University, whose former president summarily expelled a student for posting a collage on Facebook that made fun of the president's plans to build 2 new parking garages. That case cost Georgia and its insurers $900,000, and that's just in plaintiff's damages and attorney's fees. The state also had to pay 8 years of its own attorney's fees, including 2 trips to federal appellate court. Did this mistake cost $1 million? Undoubtedly. $2 million? Probably. The total cost wasn't made public, but I know this: it was ultimately paid for by Georgia taxpayers. And I know it could have been completely avoided had Valdosta State's president respected due process. How many more million-dollar mistakes will it take for Georgia universities to learn to respect due process and treat students with fairness and decency? My hope is that the legislature will soon act and make that number 0. Thank you.
Thank you, sir. I appreciate that. I was aware of that particular award, FYI, and that's another issue, members of this committee, for probably another day, probably as much in Chairman Rogers' committee and from the appropriation side of the equation. The transparency and the ability to find out what these awards are is difficult. You have to run around and ask.
Could I
That's the state accounting office. They say we don't know about that. They write the check, for goodness sake. I redact it under FERPA so that you can't see the individual names. But we appropriate this money. We need to know when we lose, for goodness sake. And somebody somewhere has a list, and I'll find it before this is over. But go ahead.
I wanted to address a couple more points just as I was taking notes. Chairman Golick, obviously a lot of people were referring to what he was saying about the parallel process that we have, and this has been a matter of confusion nationwide. I think toward the end that some of the questions actually got to the nub of it, which is there is a parallel process. They do want to have a parallel process, and the reason is that it's much easier to find somebody guilty of something, and this is, obviously I'm attributing some intent to this, but under the preponderance of the evidence standard, this is barely better than a coin flip standard of certainty. So you can find people guilty of things that you would never be able to find them guilty of in the criminal system. Now, President Peterson used the example of if somebody robs the bookstore, we might do both. Here's the thing. If a robbery occurred, it's not Schrodinger's cat. It either occurred or it didn't occur. So if you have a system where the criminal system says, no, they're acquitted, and you have the school system saying, they're guilty enough for us, those both can't possibly be right. And this idea that we should be comfortable with a system where we say, being less certain is fine. I mean, the fact is it either happened or it didn't. It's the same issue with sexual assault. The reason colleges deal with sexual assault is because it's considered a form of discrimination. Colleges have a responsibility to stop the discrimination. But if the sexual assault didn't occur, and that was alleged to be the discrimination, there was no discrimination. Like, you can't go ahead and use a lower standard of evidence. I mean, you can, and they do, but you shouldn't morally be able to go ahead and use a lower standard of evidence because you think that guy probably did it. And of course, the single investigator model just makes it, a million times worse. You're going to be exposed to every bias that a person has, either conscious or unconscious. Finally, I just want to point out that I'm actually was quite surprised what President Peterson said, that when they can't find the guilty parties, as in the fraternity case, they just punished everybody in the local vicinity, and they would do that. That smacks of collective punishment. I mean, if I break into a house in my neighborhood, not everybody in my neighborhood goes to jail if they won't turn me in. I'm sort of amazed that that's just, business as usual on college campuses. But I guess that's the reality.
I would agree, and how poignant, and we're talking about the physics of Schrodinger's cat. Well, that cat in Schrodinger's in a box. We're going to let it out of the bag in here. Members of the committee, questions?
Let me ask you a question,
Certainly.
Mr. Shibley. Oh, I'm sorry.
There you go. I got it.
Mr. Shibley, who funds you? How do you make your living? How are you?
Fire has grown a lot. When I started at Fire 12 years ago, we only had 6 employees, and now we have about 35. But we're funded by a combination of foundations and individuals. We probably have about 3,000 individual donors who give to us, and some more, some less.
Any particular foundation in particular, your biggest donor?
Our biggest donors are actually private individuals.
Really?
Yeah.
Okay. Thank you.
Mm-hmm.
Any other questions? Members of the committee? All right. Mr. Shibley, I know you came a long way. We're very appreciative. You are seeing our Kafka-esque process at work. So we will attempt to bring clarity to this issue. Members of the committee, I think you heard a lot of testimony today, the very significant testimony, a lot of things that concern many of us. Many of the university presidents are here. My Vice Chairman, Representative Williams, you had a statement. So go ahead.
Just a couple of thoughts, Mr. Chairman. I appreciate everyone that's taken time to be here today, and I know the Chancellor had to leave, but Vice Chancellor Wrigley, a few things that President Peterson said sort of raised questions with me, not so much, again, Georgia Tech specific, but system-wide, if you will, and I guess, I look at it, and again, due process versus sort of double standard or double jeopardy or two processes tracking at the same time. I know prior to days here, and I've heard folks from within higher education say, well, a college campus is different. If someone is accused of sexual assault, we can't have that individual continuing to live in the dorm for a year and those other students having to face that individual, while his case waits to go to court. And I guess the part of me that struggles with that is if someone on my street is charged with sexual assault and they're able to convince a judge to allow them to post bond, then they're back on the street and their neighbors have to look at them. So to me, we're once again facing this question, is a college campus environment, if you will, an island unto itself, whether we're talking about guns on campus or whether we're talking about the issues we're talking about today, and we're past the point in most cases where college campuses are surrounded by a fence and a gate, particularly campuses, urban campuses like Georgia State. So it troubles me that we seem to have sort of a dual set of standards. If you're on the sidewalk of Atlanta, it's dealt with one way. If you step inside the door of Georgia State, it's dealt with in another way. So I guess I'm sort of not asking you a question, Mr. Wrigley, but asking really our committee members, is it going to come down to us or the courts to really determine that issue about what is fair and appropriate for where the college campuses start and stop, and how do we deal with issues, whether they're on campus or not on campus, Mr. Chairman?
Mr. Chairman Williams, let me respond a little bit to that, because I've had significant conversations with the Board of Regents, in particular Vice Chancellor Wrigley and Chancellor Huckabee on this issue. Since the advent of these two individuals, the relationship between the legislature and the Board of Regents has come 180 degrees from where it used to be. We used to be in a situation where they just pile on with irrelevant information. Chairman Rogers remembers some of this, and many of you do too, if you ever try to get an answer. You get a clarity of thought and answers from this current Board of Regents, the members themselves, the administration particularly. As you know, we have the unique constitutional nature of our Board of Regents in this state for many reasons, going back historically to the 3 governors and many good reasons. And they have been working hard towards a Regents level solution towards this, which is their constitutional prerogative. Can we impose upon them a statutory due process? Yes, we can. I am conflicted. I have so much trust in these individuals. I want to see how that process works itself out. I will state, and this is one of the things I was going to say, and I'll let you follow up, for the members of the campuses in this room, for the individual presidents, the Regents is doing good work. They're going to come out with due process protections. But unless you missed it, unless you didn't hear what the members across this panel, Democrat and Republican alike, seem to be saying, is there's an interest in clear, simple due process protections in this state. And I, for one, as chairman of this committee, you think you've got an issue with federal bureaucrats threatening your federal funds? This committee controls your funds, each president, and I'm going to see a clear statement from all of you beyond what the Regents is required before I'm even going to have a conversation with you about your budgets, presidents. I'm not even going to talk to you until you bring a due process safeguard for the students of the state that is beyond just a simple, basic due process protections that are available. It won't take your legal department a half an hour to put that together. I mean, every young lawyer, everybody who wants to be a lawyer can enumerate basic due process protections. So hear me clearly. You got a bond project? You want to talk to us? I'm speaking for me now, but I've heard it from these legislators. If you don't protect the students of this state with due process, don't come looking for money. Period. Every single one of you. It's clear as I can put it. Go ahead.
Thank you, Mr. Chairman, and I want to state that I share the confidence that you have in the Board of Regents and in the system administration. The other question I've got, again, that can hopefully be responded to, Mr. Wrigley, at some point in the future, is a little more clarification, if you will, system-wide on the role of campus police, how they interact with municipal or non-campus police, whether or not they have the ability to directly go to the district attorney or the prosecutor, or whether their ultimate responsibility is back to the university administration for whom they work, or whether it's to the mainstream criminal justice system. I would like to learn a little more about how they interact with the mainstream, if you will. Thank you.
Thank you, Chairman. Anyone else? Any members of the committee? Ladies and gentlemen, thank you so much for sitting through this. We thank you. We'll be following up. This will not be the last you hear of this issue. Thank you.